going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Happy Tuesday. 2 days down, 3 to go. Tomorrow's hump day. All right, we can make it. We can make it through the week. We got this. All right, let's talk court. So I've got only one case for you guys tonight. It's a long one. It is a long one. It's an entire preliminary examination in front of Judge Simpson. And it's weird. It gets weird. But it is one case, so I'm probably going to have to pause it a couple times to catch people up as the video is playing and as people keep coming in. But yeah, we'll play it by ear and see how it goes. But thank you guys so much for joining me. You guys are awesome. All right. Let's get going. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Is it in the podium? Yeah. Don't let her start pulling wires out of there. No, not. See, that's what I'm talking about. Next thing we'll be wired. We'll have this place wired like a Canadian home, and nothing will work.
Canadian in the building.
I know. It's a teaser.
Thank you.
Wow.
Okay.
All right. Ready? Court does call the case of the people versus David Epps. Two cases. Good afternoon. Go ahead. They've stated their appearance. You can state your appearance, counsel. All right. Your name, sir? Thank you. All right. Are we ready to proceed?
Yes, Your Honor. Your Honor, I'd like to make a motion.
Come up to the podium. You'd like to make a motion to dismiss?
Yes, or not proceed.
Okay, or not proceed.
Dismiss.
Okay, go ahead.
Dismiss. As a matter of law.
All right, go ahead.
I told the people I was gonna make the motion. She asked me based on what I told her I would let you hear it, and then she can hear as I speak and respond. But it's based on a case that the people gave me that they were going to proceed without the complaint, and the statute is going to proceed out without the complaint. So I do not feel that this is surprise because I took what they gave me and read it.
Say that again to me.
There is no surprise to the people, in my opinion. I'm going to make the motion to dismiss because the complainant is not present.
Okay.
And they want to proceed without a complaint.
Under 27B.
Yes, under 768, 27.
C.
And just to be clear, it's people being only, I didn't give you any cases, so I've never talked to you about
Well,
this.
maybe
so
it wasn't.
it
But it was the people. I said
Just to make sure that I'm personally not surprised that you have neighbors out there. Oh, now.
People versus us, reach the 7 is that. So when I say the people, that's what I mean. I'm not.
Right. No, that I get you.
Right? But the people, that's where I got it from. I know who it was, the color. Oh. Wait.
Oh, you're welcome to get me mixed up with Jessica Fletch. I'm
gonna keep this.
Is this volume kind of really loud for everyone else as well? I feel like it's a lot louder than normal. I'm going to turn it down a little bit. Let me know.
Holding concern, all right?
Right.
All right, based on the complaint, it's not here. number one.
Correct.
She has made statements to the people and the police. She does not want to proceed. All right. But specifically, if you look at people versus only 327-319, that's what we relying on. Because in that instance, the court did let the testimony in. The complainant did not appear. The court let the testimony in. In that instance, though, the complainant had talked to the police officer specifically. She said that the client broke in, was her ex-boyfriend, however you want to look at it, broke in, demanded money that he had loaned her, took the money, knocked her on the floor, and strangled her. The police officer observed red marks on her neck and some other corroboration, I think, bruises on her. Okay, that's totally different. So that is why I believe that case is highly distinguishable from this. They cannot rely on that. So they use the statements that that witness made directly to the officer right under the immediate occurrence of the incident. That's the other thing that's very important. Right after it had happened, because 911 was called right as it was occurring.
I've read it. Yeah.
So you didn't have time for reflection, you didn't have time for manipulation, you didn't have time for creativity, fabrication, or any other thing. And that's one of the protections why this goes to 76827C. If you look it up, it's based upon the court rule, the excited utterance, right? So that's sort of it is.
Well, it's based on that, but it goes a little bit. Yeah,
It's
go
based
ahead.
on that the incident, that the statement was made spontaneous or in concurrence with the event or shortly thereafter. Present sense impression as well, the state of mind. That might be a little bit longer, but that's not what the statute is. It's like C. If you look up C, it says there must be a sufficiently startling experience, suspending reflective thought, and a spontaneous reaction, not one resulting from reflection. That's what you see is based on. Okay, that's not here. That does not exist here. They never talk to the complainant.
That's another point, Your Honor. Could I just ask a simple question? This is in the unlawful inference. It's just a question.
No,
Because it's
I'm gonna get to that. Then I'm gonna tie it up in a minute. I have to lay this.
Okay, go ahead.
That's what she wants you to deviate to, but I say.
Wants me to deviate to?
Well, I'll tell you, if prong one is not satisfied, the matter should be dismissed. What they want to do is piggyback their case on statements that my client made while he was in prison, or statements the complainant made while they were on the phone. I'm saying this case should come in the first place. So now this would be like fruits from the poisonous tree. It's like, yeah, it would be. It's
Why?
like, I'll tell you. It's
Okay.
Like, I had a case once. Police said they stopped the guy because he was a stop sign. The stop sign never existed. I proved that with records in the city, right? Therefore, that was a fallacious reason to have the probable cause. Then it was after the probable cause, the fallacious probable cause, they said that there was plain view sight of a gun. And after description of the gun, the weight of it, on and on, I was able to show that that search was a fruit of the poisonous tree or the stop. That's exactly what these calls would be. Because they can't come in because they weren't, as I said, she's not here. And she never talked to the police. Now when you get to the phone calls at the jail, that's much further in time away.
Nima, I think we're watching that right now. I'm just saying. She's a little over the top. She's loud. She's passionate. Good. You know, if I was in the defendant's shoes, I would want an attorney that was fighting this hard.
If you were thinking about it, from the date of the incident, which I believe was August 5th, 2024. So it doesn't qualify under 768.2.7C. It's far away in time, and it deprives him of its right.
That is hilarious, Kelly. Mimi, are you still here? Is this one of your neighbors? Do you know her?
Confrontation under the Sixth Amendment, he wants me to tie clothes up. It's a serious matter, it's a real argument. He wants you to take on people versus the state, bring them to bar will. But it is the president of this part of the consultation. They leave prong one. Now they want to piggyback on the jail calls, which were far away in time and don't need the hearsay exception. They're cited in their case, people work for some or the statute. The violation, it's real law. It's real law.
Okay.
Constitutional right that does not apply to preliminary exam. The Sixth Amendment is a trial right. I'm speaking now with my daughter. Thank you. Last time I checked, we were not at trial. The preliminary exam is a statutory right. People may bully the entire and run specifically states the Sixth Amendment does not apply at the preliminary exam. I don't know who told Ms. Ford that I'm moving forward under 27C today. This is not a 27C case. And if I had just had the opportunity to ask my question, we wouldn't have had to sit through that entire argument. My question is, at what point in Pittsfield Township Police Report number 24-16611 do you have a victim statement in there? Because the victim statement is what allows somebody to move forward under 27C. I am not moving forward under 27C. This is an assault that occurred on video. I don't need the victim statement for me to play the video of him punching her in the face and slamming her back into a vehicle and then speeding away while she's trying to exit the vehicle. Then he confesses to the officer. So his statement that I will be admitting as a statement against his interests under the Michigan Rules of Evidence is how I'm moving forward. That's not 27C. What's also not 27C is his witness intimidation. While he is in the jail, calling the domestic violence victim from the jail, telling her, call the prosecutor, tell them you don't want to move forward with charges. Did you talk with the officer? What did you tell the investigator? And she says, you bet I did. That's not 27C either. That is also non-hearsay statement against the defendant's interest. I'm ready to go. Just briefly,
All right, Ed, to answer your question, Heather arrives on Saturday. She gets here Saturday, middle of the afternoon, and she's here till the following Sunday, I think? Or is it the next following Saturday? It's either Saturday or Sunday. She's here for a week. So, yeah, Saturday afternoon.
I said that he would. I've said pretty much what I had to say, that this statement cannot come in independently.
Which statement are you talking about, counsel?
Any statements by the complainant cannot come in without the complainant's testimony in this instance. Or a legitimate.
Hold on. Counsel. So I'm pretty sure we're talking about the right case. Because you started out with a 27.3 or 27C argument. But my understanding when I hear from the people is this isn't a 27C case, that there is video and then the defendant's alleged statements that are underlying the primary case. And when I say the primary case, 1055, the unlawful imprisonment and domestic violence.
So
there.
The statements were made at the time of the event.
Which statements?
Defendant's statements. He didn't give a statement. And so the statement.
Yes, he did. That's what they just said.
Officer Wilker confessed to the crime. She's going to testify to that today.
That's what I understand.
Hold on, Mr. Epps. Hold on. I just want to make sure we're all operating off the same page because what I understand is Ms. Ford. Hold on, just folks. I'll let you have your conversation. I want to get out what I want to say. My understanding is this isn't a 27C case. That at least what they're alleging, and I've not heard any testimony, so I don't know. I'm hearing what they're telling me at this point is that there is video evidence of the defendant committing certain acts. That then subsequent to that, there is then an admission to a police officer as to those acts or some portion thereof. That's a whole different thing than 27C
All right.
and having that. May I also then say, it seems to me that part of your argument was going then to, I'm presuming, jail calls or other things in which the defendant would have said certain things. This is how I'm envisioning this, and I may be slightly wrong interpreting it. That there may be responses from the alleged victim in regard to what the defendant may have said. Again, I haven't heard it, I don't know. But if that's the case, and there's statements in which she may have said, well, and I'm just giving this as an example, I'm not saying it's what it is, that he says something, she says, okay, you're right, I'm not going to show up, or I'm not going to do something, or whatever. That's, and then she's not here, or even actually his act of doing that, depending on what it is, really constitutes the second case. So that's where I think there might be a disconnect as to exactly where this is heading. I don't know, because I'm not involved typically in conversations that council's having. I don't know what may have been told to you by somebody before, but I'm presuming you had the discovery package and could see what was there.
Correct.
So I would anticipate that without the victim being present in this case, that the people would be proceeding with video evidence of these alleged acts, and then the officer's testimony of the defendant's statements. And then if that proceeds, then there's then the stuff that occurred afterwards.
Thank you.
So regarding your motion, I would have to deny it. Do you wish, before you leap over there, Mr. Evans, do you wish to have time to go back and talk to your, that was a lot there. And I don't know,
They're about to take their first recess in about 1 or 2 minutes, and I will give a quick recap then.
saw Mr. Epps trying to talk to you first, and then I kind of stopped him and then did whatever, but I want to make sure he has time.
Let that video play.
You want it played?
Yeah.
Oh, have you seen it?
Yes, sir.
Okay.
Stipulation to submission.
Are you stipulating to its admission?
Yes.
There's, okay, so I just want to be clear, Mr. Epps, you don't want time to talk to your counsel about what just happened and what I just, because about how they're going to proceed. I get you get the video part, but the other part of it, I don't.
With my understanding, what you're saying, a case is built off of video. I already saw it.
Well, no.
Well,
it's
the
built-
video will show this alleged,
Okay, this is part of the problem, Mr. Evans. It's not that I won't hear from you, you know that. It's just that I don't want you saying something that might be used against
Oh,
you.
no, I know what you're saying, I know what you're saying,
Okay, but that doesn't always do it. I'm just saying, when you say to me that their case is built off of that, there's another big piece to that, and that's supposedly your statement.
okay, and I understand that too.
Okay. And then that's that first case. And then there's the next case of what may be, I'm presuming, statements by you on the other case, the bribing intimidation.
And so, I wanted to ask you,
Yes, sir.
I know my Sixth Amendment. It's my.
Hold on. Yes. And here's what I'm gonna do. I'm gonna take a break. Have you taken back? I want you to, because you're asking questions. I could certainly answer them, but I'm not gonna step in between the attorney-client relationship. And so I want that question, I want you to talk to your attorney about that. When you start getting into that issue. Because certain things you may think apply at this proceeding may not apply, but I want you to get your attorney's advice. So what we're gonna do is let's take Mr. Epps back, let's get him, and then Ms. Ford, you can go around and talk to him and answer any questions that he might have regarding that.
I want to answer more. Just he has not heard every single jail call from me, but he has.
What do you mean?
I read the jail call.
There's a written statement summarizing the jail calls. The voice mail of the jail calls, I guess, he has not heard everyone. I saw him, but they're extremely voluminous. So he is ready to proceed. He knows what the jail calls say. Well, number one, it was on. But number two, there's a summary of it in the discovery. So he has seen all of that, and he still wants to proceed. Is that correct?
Okay, you're still gonna need to ask that other question, answer his question. So I understand that. Can I just say this so we don't run into a problem? I realize he saw a transcript of calls, right?
Yeah.
Okay. Can I just ask, and I don't know whether it's the case, and maybe you know, maybe you don't know. Are those the transcripts that he saw? Are those the calls that the people are proceeding on as part of the case?
Yes, the jail.
Well,
Yes.
okay, I get it. But my understanding is that there are jail calls that he has not heard, but he's read.
Yes.
And that he wouldn't have read all of the jail calls because were all of them transcribed?
Not every last one.
Okay, so then my question becomes, are the calls that the people are relying?
All right, I massively underestimated how long the first part of this clip went. I thought it was about to be recess time. Ed, it is, yeah, no, it's absolutely possible. If you know, so St. Louis County, just look up the court website, and they'll have. You're gonna have to type in the person's name, but then everything will pop up, so you can you'll be able to see, you know, their charges, when their court date is, what time, what judge, all that stuff. You can, if you're having issues, you can always message me in Discord or email, and I can look it up for you. Okay, I swear this is almost done. I'm going to recap the first part of this, but yeah.
Relying upon for the case, he hasn't heard any of them, I'm presuming, right? But has Mr. Epsman provided the transcripts of the calls that the people would be relying upon to form the charge?
Yeah, I did talk to the people yesterday. They said they may or may not use any of the specific calls. They may use the summary of the calls.
The answer to your question is yes. Every jail call that I will be using today is in the police report that's been provided to them. I understand he's read that.
And he's read that, okay.
Because we did discuss that yesterday.
Okay, I'm trying to make sure I'm not part of those conversations. So I'm just trying to make sure Mr. Epps' rights are protected. All right, let's take him back. Let you talk to him. I'll try to handle the other case and then we'll come back out and try to do this. Whenever they can bring him out.
All right, there we go. There's the first recess. And Batmom, I don't really understand your question. I don't. The judge is the one who decides the bind over, and the bind over just means it's going from district court to circuit court, because Judge Simpson won't do felony trials or felony sentences. So that's what the bind over means. So, but I don't really understand your question, but I don't think it has anything to do with the attorneys. But again, I could have misunderstood. Okay. For those of you that came in late, the first half of this was a lot. It didn't need to be that long. But the defense attorney asked for a dismissal of the case because the victim wasn't there. The complaining witness was not there. So they asked for a dismissal, and the state, the prosecutor, said, we have all the evidence we need. We can go forward without her. And that's where all the rules came in. But the defense attorney was very animated. I don't think she was yelling. I just think she's a loud talker. But it came across as she was kind of yelling at times. And then the defendant kept making his comments from the table as well. So that pretty much catches it up. So they just took a break because what just happened, the defendant's upset. So judge sent him back to the holding area so his attorney can go talk to him, kind of calm him down, and then we can actually go on with the prelim. And they do. Hey, what's up, Erica? Good to see you. All right. Is that good? I think I recapped it pretty well. Okay, let's go.
Here we go. Can you bring it up, please?
That probably was something I should have said. It is some sort of domestic violence. So it's a DV case, but the biggest issue for the defendant is he's been calling the victim from jail. So that's where they were talking about the jail transcripts, the phone transcripts, or what he called when he called her from jail. So there's witness intimidation, plus there's a DV case, and she's not there. So it doesn't look good for him. Okay, that was important information. Thank you for asking that, because I did leave that out.
Court does call the cases of the people, state of Michigan versus David.
Yeah, that's discovery. That goes both ways. So the defense has to show. Well, the defense doesn't really have to show anything unless they're bringing their own evidence. But it's not up to the defense to bring evidence. It's up to the state to bring the evidence, because the defense doesn't have to prove innocence. The state or the prosecutor has to prove guilt. So the defense really doesn't have to bring anything unless they think it can, change the course of the case. So generally, all the defense will bring are witnesses, and that you have to share witnesses. But sometimes there is stuff. So that's why a lot of times when you see the defendant and the defense attorney get into fights, it's because the defendant wants to bring all this evidence in, and their counsel's like, no, you don't need to prove your innocence. You do not need to do that. They have to prove your guilt, and we can bring whatever you say in when they bring it up. You don't just throw stuff in because you could inadvertently give the prosecutor something they didn't have. Okay, I hope I answered that. Now let's go.
Thank you, sir. Date time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, thank you.
Yes.
All right. Let me call your first witness.
Thank you. Start by calling Officer Wagner.
Take a seat, raise your right hand, and solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah, the caps didn't bother me. As long as you just didn't have it stuck and that's the way you type, then I would have called you out on it. But they didn't bother me.
See, same spell your first and last name for the record.
Officer Jessica Bunker. WTLKER with this department.
Thank you. You may inquire.
Thank you, Your Honor. Officer, where are you currently? Thank you. How long have you been employed as such?
Pittsfield, I've been employed there since October of last year, but I was officer for 10 years.
Prior to Pittsfield, you were with Ypsilanti Police Department?
Yes.
Thank you. Were you working in your capacity with Pittsfield in July of 2024? Specifically on July 28th of 2024?
Yes.
Are you familiar with the address of 5550 West Michigan Ave? Washington County, Michigan. Yes, ma'am.
All right, everyone. I just turned the volume down because the mics are coming in really hot. If it's too low, I think it's a little too low. So I'm gonna turn it back up a little bit. But I don't like how hot the mics are. So if anyone can't hear or they're too hot, let me know and I'll adjust it along the way. But I feel like their mics kind of suck and they keep going up and down on their end and not mine. So I'm trying to adjust it on the fly.
Intersection of wishing at Carter.
How did you come to be involved in this investigation?
I was on the 11 and inspection myself at McDonald's. Initially based on inspection information, we were dispatched to the one a little bit farther up north on Carter Road. But based on the description of there being construction, we realized now that Sam's level Carter
So for instance, you had the opportunity to arrive on scene at this McDonald's. When you arrived on scene, was it approximately 2:07 p.m. or around that time?
Yes.
When you arrived on scene, did you have contact with someone by the name of Shanora Harris? To this point in your career as a police officer, how many times have you interviewed Shanora Harris in person?
I knew Ms. Harris from Ypsilanti PD, so I couldn't tell you how to end up there, but as far as interviewing her on facts of this case, I did.
Thank you. Did you make efforts?
Yes, I called her to verify her welfare and asked her to talk to me FaceTime to speak with her about things and she refused.
Thank you. When you arrived on scene at the McDonald's on July 28, 2024, did you have the opportunity to speak with witnesses? Specifically one male witness?
Yes.
Without telling me any of the information that he told you, did you also have the opportunity to speak with staff members at the McDonald's?
I did.
When you spoke with staff members at the McDonald's, did you make any inquiries about Shanora Harris? Meaning, did you ask them any questions about somebody named Shanora Harris?
No, it was presented to me.
Thank you. Did you have the opportunity during your investigation to look into surveillance footage? Why?
Excuse me one moment. Can you call Mr. Banner? Go ahead.
Why did you look into surveillance footage?
Based on the allegations, and without really direct statements being by the there's a solid allegation. Therefore, I requested surveillance footage of the business on the outside. Where the alleged incident was supposed to happen, and was able to obtain.
Did you understand Shanora, employee of that McDonald's?
After interviewing some of the other employees, yes, that information was provided.
And did you have the opportunity to review surveillance footage from that McDonald's as it relates to July 28th, 2024?
Yes.
When you reviewed the surveillance footage, where were you initially?
Reviewing the footage, I went to the location with one of our detectives, reviewed the footage there, with the employees, who gave input, which is what led to get information from Ms. Harris, as well as after the fact, to follow that decision.
Were you present when the video was being downloaded or extracted from the McDonald's?
Yes, I was.
Thank you. Your Honor, I am plugged in. How do I get connected to this?
Got her. You are connected.
Thank you very much.
All right, just a fair warning. I do not know what's in this video. I was doing something else during this part of the prelim this afternoon. I don't know what's in the video. So if I have to skip ahead because they're showing certain things, I'm going to have to skip ahead. But I'll try to play as much as I can. But just a warning to everybody. No idea what's in the video. But I'm going to guess it's the incident. And it's a DV case.
Officer Walker, can you see the screen of the courtroom?
Yes, ma'am.
Are you familiar with what is presently on the screen?
Yes, ma'am.
Could you please describe to the court what this is?
Of course. This is a pole cam that faces the parking lot of the 5550 West Michigan Avenue McDonald's at intersection of Carpenter Road and Michigan Avenue.
And the screen that I have it stopped on, have you had the opportunity to watch the video from this point forward?
Yes, ma'am.
And is this a fair and accurate reflection of the video that you took into evidence as part of this investigation?
Yes, ma'am.
Your Honor, at this time, I would move to admit People's Proposed Exhibit 1.
Any objection or voir dire? Okay, and I've already ruled on that. Is there any objection to this piece of evidence coming in? Exit. So that the record's clear, I've already denied that, so I hear no objection. Exhibit 1 is admitted.
May I just place on record to say more that it would be a continued objection? I want to say.
And my ruling will be a continual one of a denial. Go ahead, Ms. Hughes.
Your Honor, may I switch?
Yes.
That's as good as I can make it, Mike. As good as I can do, right there.
Have an understanding of who the person is that was dragged and put into that vehicle?
Yes, ma'am.
Who is it?
Nora Harris. Your Honor, I would just like to place an objection like a foundation type of.
Yeah, that was bad. I'm glad it wasn't. It was kind of far away. I'm not going to get in trouble from YouTube because it wasn't clear, but we all saw what he did. She was trying to leave. He didn't let her leave. Obviously, it looked like he assaulted her. So, yeah. Now I see why the defense attorney was trying so hard to keep this out of evidence.
Who either person was in that video.
Certainly, I can lay that.
Yes, go ahead.
Did you have the opportunity to interview somebody by the name of David X?
Yes, ma'am.
If you were to see Mr. Epps again, would you recognize him? Of course. Is he present in the courtroom today?
Yes, ma'am. He's sitting next. He's sitting next to.
I am so jealous, Mimi. I hope you had a great time. I hope you had an amazing time. Great to see you, by the way.
Thank you, Your Honor. Please let the record reflect the witness identified the defendant.
Without objection, record shall so reflect.
Did you have the opportunity to interview the defendant?
Yes.
Where were you when you interviewed the defendant?
It's not 100 with pharmacy.
Thank you. Was the defendant in your custody at that time? Prior to the interview beginning, did you read him his Miranda rights?
Yes.
How did you do so?
I read the Miranda and I reviewed them beside next to individual rights as well as a follow up form. Best if you have it force like threat in any way.
At the conclusion of reading him his rights, did you understand that he was waiving his rights and wished to give you a statement?
Yes.
Did he give you a statement acknowledging that the person that was put into the vehicle is Shanora Harris?
Yes.
Did he give you a statement acknowledging that the person that put her in the vehicle is David X?
Yes.
So going in order of his statement. So first, I apologize if you already said this. Did this interview occur on August 1st, 2024?
Yes.
Thank you. At the beginning of your interview, did you indicate what you were there to speak with him about?
Yes.
At this time, when you started the interview with him, did you know Ms. Harris's whereabouts?
I did not.
Did you have any concerns about her whereabouts?
I did.
Could you tell us about that, please?
Yes, go ahead.
Starting with the timeline of the incident, that's all right, I'm not explaining like the time she were.
Thank you.
The incident happened on July 28th. at McDonald's, and that was the last time that anybody had, got snucker. We had her on camera, and that's the last time anybody had said anything. I wrote to Mr. App's statement, he claims that that's the last time that he saw her, and they got into a conversation verbally, and they really not. After that, very good, her items, her social security card, various items ID were located on the scene of a shooting in International. And we couldn't find her.
May I interject one thing? Does she have a statement where it's sworn, in his handwriting, where he's written that and he's signed it?
No, ma'am, it's on camera and I heard her.
I'm going to just continue.
What are you objecting to, though, counsel?
I don't see a signed statement of him, but I know I don't see a signed statement. So that's.
Okay, but have. I'm sorry, the interview or statements that you're relating are on video.
Yes, Your Honor.
Have you been provided a copy of that video, counsel?
Yes, I got discovery, it didn't all pop up. That's.
Well, what does that mean?
Some of them pop up, the pictures pop up and some don't. Really, like, push to see various parts of discovery, some pop up, some don't.
Okay, but here's my question. With reference to the statement that the officers testifying, which you're objecting because it's not in writing, did you receive, you have what?
I have a summary of it right here.
Okay, I understand that. But did you receive a copy of his video statement?
I got to discuss.
Not my question, counsel. Did you receive a copy of the statement?
Yes.
Has your client had an opportunity to see that statement?
Yes.
No, I never saw it.
Okay, I can't. Let me ask you this, because otherwise we're going to run into this at every stage. Has the discovery that you received, has that been shared with Mr. Epps?
Not all of the videos.
So what videos haven't been shared?
I saw the one, that we just played, sir.
Okay, got that. So there's a video of the statement.
But I did not show him. But he knows it in terms of the written stuff, but not the videos.
Oh man. Oh man. Judge was frustrated. J Fire, happy birthday. Happy birthday. I was gonna wait to pause it until after this little frustration episode passes, but I will always pause it for someone's birthday. So happy birthday, J Fire. I appreciate you hanging out with us on your birthday. Erica, here's the super chat. Now answer the question. What question am I supposed to answer? I was reading this and I started going back through the chat. I didn't see a question. If I missed a question, I apologize. I did not know. It was not on purpose. Thank you for the super chat, though.
I get you. Just stop. So, counsel, you can't, the officers up here testify. You're objecting because the statement isn't in writing.
Right.
But you're not objecting to at least the substance of what she may be saying.
That's correct. Before we got started, I did mention to my client that certain videos that I've seen, I asked her.
But hold on, counsel, I'm gonna stop you right there. When we were going through your previous argument, one of the issues that you were trying to say it was a 27C case that Ms. Hughes specifically brought up was your client's statements.
I'm really trying not to pause it right here, but yeah, I missed it. When broken system, broken trust comes in, I kind of just I don't really read his comments. I honestly don't. I feel like sometimes he tries to get under my skin, sometimes he tries to be nice, so I just whatever. So yeah, now I understand it wasn't meant for me, but thank you for clarifying, guys.
And so if you knew. Counsel, don't you think your client should see what he's telling me? He doesn't have any idea that it was recorded. I don't know if that's true or not. It doesn't matter. Because the thing is that clearly that's evidence against him. Would you not agree that he should at least see that? He may not like it, he may not whatever, but he should at least see it. Not right this second. I'll hear from you, but just not right now. Okay. How long is the statement? An hour.
At least the recording.
Right, but the recording of his interview is okay. All right. Hey, what do you want to say, Mr. Epps?
I didn't have no knowledge, and I don't think she had no knowledge of the video. This is just coming out today. That is
Had no, say that second.
knowledge of a video. This is just coming out today, sir.
Well, hold on. I don't mean, I want to make sure I understand what you're telling me. I hear you that you're saying you did not. And then you're saying that you don't think counsel did.
No, but this is just coming out today that it was video.
I shared a video with Miss Ford on August 9th, 2024, and it was downloaded, and she still has another 52 days left if she wants to download it
Excuse me, bro.
again.
No, that, yeah.
Sorry, you're on a minute. Approach the witness for just one moment.
You may.
Thank you.
So. I don't know that I can. Mr. Epps, I don't know where I can answer your question, the second part. I hear what you're saying, but I don't know that I can answer that. All right. The only thing I am concerned about is, Ms. Ford, whether you knew about it or not, because I don't know, and I'm not going to get into that at this point. Wouldn't you believe that at a minimum right now, as we sit here right now, that your client should be entitled to see that video?
Yeah.
Okay, folks,
Mimi! It's good to see you, Mimi. It really is. John, working for the 12 months. Yes, 7 months. That is awesome, John. Thank you so much. I appreciate it, bud. Mimi!
Officer, you may step now.
Thank you.
All right, I'm going to adjourn this. I want every Miss Hughes, you indicated that that was sent to counsel.
Yeah.
All right, Ms. Ford, do you still, hold on. Do you still have a copy of that? All right, but no, just stop. That video is to be shown to Mr. Epps. Now, how many other, Mr. Epps, you said you saw the one that we just saw, right?
Yes.
All right. How many other videos were sent?
16 videos were sent and 4 pictures were sent.
So 16 videos, 4 pictures.
Yes, separately, there are jail calls as well that are, I sent directly to her by email.
Okay, I'll get to that that's on the other case. All right, so Mr. Epps, let me ask you this. Of this, I'm just trying to think of the correct way to phrase it. How many videos did you review? Let me put it that way.
I reviewed the one that we just saw, and I heard phone recording.
Hold on. I don't want to get into phone recording. I'm talking just about videos right now. How many so what I'm hearing from you, you've only seen one.
Yes, sir.
Okay, so that's. He's got to see the other ones. Some of them may not mean anything at this point, but certainly if they're proceeding on his confession, and he's got to at least see that one, but he should see all of them, or at least have the opportunity to see all of them. Those videos all relate to the case ending in 1055. Is that correct, Ms. Hughes?
Yes.
Okay. Now, there are also, and we were kind of getting into this before. He's seen the transcript of phone calls, but Mr. Epps, I'm going to ask you again. You haven't heard the calls.
Yes.
Pardon?
Yes.
Okay, I asked the question badly. Have you heard any of the calls?
Some of them.
Okay. The ones and you may or may not know this, the ones of the transcripts that you read, did you hear those calls?
Yes, some of them.
Okay. But you haven't heard all of them. So let me ask you this. Is there some of those calls that you're reading what the call said, but didn't actually hear the call?
What's that?
Was that correct, what I just said?
Yeah.
Okay. Okay, so Ms. Ford, how many, I don't know, I don't want to put it that way. Is there a reason why the calls themselves have not been provided to Mr. Epps to at least hear?
None other than I saw him and I told, their calls last for hours and I told him they lasted a long time. We discussed what they said, but other than that, no.
Okay, so let me ask this. I realize the calls may last for a long time, but and so that there may indeed be calls that he just doesn't need to hear. I mean, whatever, because they're not going to really be part of the case. But has he heard the recordings or had an opportunity at least to hear the recordings of the ones that are transcribed?
No. There's about 11 of them, no.
Okay, there's about 11 calls. Is that what you're telling me?
Mimi, I'm so sorry to hear that. That's unfortunate. Yeah, I've got no experience with the HOA, so I have no advice for you. I am sorry to hear that though. That sucks. Good thing you just had a 2-week long vacation, and apparently you know how to sports bet. So that's good. I'm guessing that's how you won money. I didn't ask, but I'm assuming that's how.
while it may or may not be important, those 11 calls, the transcription of those 11 calls, are they accurate?
I believe so. I believe that. The client can't say because he hasn't heard the direct call.
As to the calls, because we kind of dealt with this earlier, Mr. Epps. Mr. Epps, did you want an opportunity to hear those calls and to attempt to try to verify those calls as against what you read?
I wanted to call playing in court, so.
Well,
Yeah, I'm trying not to pause it too much. I believe the attorney is appointed. He's been in jail for a while. I'm going to assume appointed. I don't know the absolute answer to that. I think we'll probably find out at the end, because I'm not going to tell you how it ends, but sure, we're going to find out with what happens.
do you know what they say? So let me ask you this. Why would you want them played if you're not sure what they say? And I'm just saying this. Let's say what you read is not what's on the call.
Yes, sir.
Why would you want that played before you can hear it yourself as to what I'll hear?
Sir, I'm currently on parole right now.
Right.
And I had they have an evidential hearing before you go to your immediately your hearing.
An evidentiary hearing before you go.
To your immediate hearing.
Right.
The charges that I'm facing. So the call is very vague.
Right, okay, stop, can I just stop you there?
Yeah.
Right now? Because you're not gonna have that type of evidentiary hearing before this proceeds. I see why you say you want to play in court, I get it. That's not the way this procedure works. Okay, so if you, in what you just said, that you think the calls are vague and may not mean what they mean, it's going to be important, frankly, for you to hear the call. I would agree with you that sometimes on paper, something can say something, but be said in a way that that's not really what's meant. I think that's what you're trying to tell me when you say vague. Is that right?
Vague, when I say vague, meaning that you can't hear it, like you can't hear.
So they're faint.
What's going on?
So
And maybe
hold on a second. When you say that, what's on the paper that you read then about the call? If you can't hear it, huh?
yeah, you like when I'm doing my interview, my parole interview, they play it on the screen.
Hold on. You're at another hearing I'm not part of. So were these phone calls part of some other hearing?
Yeah.
Okay, so at some point you heard them?
Yeah. But it was like I said, you barely can hear me, you know what I'm saying?
So in other words, hang on, I got you. So in other words, some of you have heard, but you're not sure then what is transcribed is what the written part is what's on those tapes.
Yes.
Which is why you wanted them.
Mimi. Wow, that is extremely generous. Thank you so much, Mimi. Thank you. Mimi! I'm so sorry that you're having a tough time with your HOA. Again, I don't know anything about HOAs. I saw Mac was trying to give you advice. I don't know anything. I really wish I did so I could help you. I live in an apartment and I owned a house that wasn't an HOA, so I got nothing. I really can't help. My experience from just watching videos on HOAs is they suck because every video I see, it's how bad they are. You never see anything that they're doing that's good. I'm sure that they do a lot of good, but as far as videos on the internet, you don't see the good they do. So I'm really sorry you're dealing with this, but that is an extremely generous super chat. Thank you so much, Mimi. And Peeps, I am so sorry I missed you, Peeps. I am so sorry. I just looked and I saw that you were before Johnny, and I said thank you to Johnny, but not you. Peeps, thank you so much for the 8 months. I appreciate it. I appreciate it. You do got this, Mimi. You got this. You got it.
Played because you think, okay, I got you. Not a good way to handle it, but I got what you're trying to tell me. All right, this can't go this way. So, I mean, even if one were to say that he doesn't need to hear the phone calls, and one might argue, or he's part of the phone call, so he knows what they say. I mean, maybe that argument could be made, but there's going to be no excuse for him not seeing the videos. None. Seen all of the paper discovery against you, Mr. Epps?
Yes, sir.
Okay. So I just wanted to make sure. Okay. So here's what I'm gonna do. I'm gonna adjourn this case to October 8th. Counsel, I don't care how you have to do it, what configuration it needs to be done in, or how you need to arrange that with the Washington County Jail. But you are to arrange so that if you got, I don't know how long these videos are, but if there's 20 hours of video, you're going to sit there 20 hours and make sure he has access to those videos and can see them, as well as that he has access to the phone calls. I am not going to accept as some type of an excuse that there might have been some difficulty with the jail or some issue in terms of that. I'm not going to accept it. If you got to sit there all day and night till you get in to see him, you're going to sit there all day and night till you get in there and see him, and he gets a chance to see it. He may not even like what's on the video, and that's fine, but he should at least see what's being used against him.
I see.
I would like counsel to withdraw. I went over this several times with her about this video, and like she said, she complained that the video was long. You know, I knew it was appropriate to see this video, and I asked my counsel several times, could we see this video? Could we go over this video? I also told her the proper way to let me see the video, that she will have to bring a laptop in, because I've been through this before with a prior counsel, you know, and it's just like, right now, I'm embarrassed, because it looks like my case is just all over the place. Me and my counsel, like, we weren't even ready.
I didn't complain it was on, but he's right, I didn't bring in the laptop. One time I did, actually, one time I did.
What do you think is going through Judge Simpson's head right now? He's listening to a defendant throw his attorney under the bus for good reasons. She didn't show him, from the sounds of it, 75% of the evidence because it would have taken too much time. How can you say it's going to take too much time? I'm not showing you this. In a nutshell, that's what's going on right here, at least in my opinion. Okay. Sorry, Judge Simpson. This was a rough day for you.
You understand if I do that, Mr. Epps, that this would further delay your proceedings.
Yes, sir.
You understand that that's a possibility, that it would be further delayed.
Oh, this defendant's been a doozy. This isn't the first time I've covered him. When he was asking for a bond reduction, and then the prosecutor brought up all the calls to the victim, and then the victim said that they were no longer going to testify. Yeah, yeah, I don't like this defendant at all, but his attorney is like they need to separate. Get them away from each other now. That officer in the back needs to sit between them.
I don't want no delay. So I guess I'll just go ahead with Thompson.
Well, Mr. Epps, I wasn't trying to lean you one way or the other. I'm just trying to. Dear God.
Your Honor, we just came in here.
Mr. Epps, I'm hearing you. Okay.
He hasn't seen all the video discovery. There was a firm plan I found.
Pardon?
The gist of the plan I have found. He has not seen all the video discovery. That is true.
I'm acutely aware of that. Today is what? Well, all right. Let's do this. Let's take Mr. Epps back. Mr. Epps, I'm going to think about your request and that whole issue of delay and see that. Give me a minute to try to make a decision on that, okay? Because it's.
The one thing on your radar is continued use of the jail calls, just to put defense counsel on notice that I will be addressing that when we come back.
You will, what?
He has continued to call the victim of the jail.
I just found that.
Oh, okay. Yeah, thanks, because there wasn't enough on my radar. I do appreciate it. I do appreciate you.
Like the cliffhangers.
Court's gonna stand in recess.
I don't think she can necessarily get disbarred just for this one incident. Now, if this keeps happening and then grievances get filed against her, maybe. I don't know. I don't know the standards of infractions and grievances that you have to obtain to be disbarred. I really don't know. I mean, she could always just use the defense. I watched them and they weren't relevant, so I didn't show them. Even though that's not okay. I mean, it's at least a response, a defense to it. I don't know. All right. Am I all caught up with everything? We're going into the last part of this video. I think I'm all good. You guys are awesome for hanging in here. I know this is a long one. We have there's about 10-ish minutes left, 10, 15 minutes left. All right. Everyone that's come in a little late, I will try to recap just real quick. So the defendant is charged with domestic violence. He then was calling the victim, the complaining witness, from his jail cell and got his phone privileges removed, but the victim also backed out of testifying against him. So the defendant thought that the case would be dismissed because she wasn't testifying, but then the state's like, no, we have this on video. We don't need her to testify. So the video was shown. The defense attorney tried real hard to get the video thrown out. Did not work. They played the video. And, it's been for lack of better words, it's been a shit show since. Okay. I think you're caught up. If you joined, you're now caught up. Now let's finish it up.
Okay.
It's a good point, Sherry. That's a good point. I like to think that most judges are this way, but no, I have no idea.
Recall the case of the People versus Epps. Counsel, please state your appearances. All right. Thank you, Ms. Rose.
Your Honor, may I say a couple things?
Yes.
We talked, thank you for your time. We talked a lot. And,
Yeah, no, yeah, no. Heather is coming to visit me. She's gonna be here on Saturday. Speaking of which, that's why the PayPal's pinned or the link tree's pinned. If you guys want to donate to the Colin spoil the crap out of Heather fund, it's up there. No pressure though. It's just pinned there. But yeah, no, Heather is not pregnant. Do not worry. No, no worries, Erica. No worries. That's funny though. It's not the first time that's been asked though.
Mostly I'm completely. And at this time, I do not believe, we both went back on this matter, whether or not I should be his lawyer, in my opinion, if we both went back and forth. But in this last 10 minutes, he told me he thought it was best that I not be on the case, and I'm just going to agree. This is the first time I've ever withdrawn, ever, since I've been on Wall Street. But I think the defect can be cured with the statement and the discovery. That can be cured. I could stay there 2 or 3 days. That's fine. I think if I can't win, that's not fine. I think if he gets blocked on that flow, that's very not. And I cannot promise a blueprint and battle plan on every question he has, and that's what he is very intelligent. That's what he wants, a battle plan. When I say I think, that's because I know the various ways of matters can go. To him, that's weak. To me, it's insightful and knowing very a bunch of nuances and not promising something's gonna go one way when I know good doggone well it can go sideways or it can go in another direction. So I have a difference in style that doesn't meet that right there doesn't meet his need. He needs a battle plan. Someone say, let's try to win this war, period. Whether we win it or not, that's not my style. So between all those reasons, he deserves what he wants. There are lawyers that will do it. He deserves it.
All right. Okay. Yeah, well, let me just say this. Sometimes I think that, having been a practicing attorney myself previously, that I think sometimes clients have a greater expectation. And I think that's what you're getting at, Ms. Ford, about things. And about what can happen. Having to apprise a client of the particular risk. And then saying that something is going to go exactly along a certain lines. And that's not the way the law works necessarily. And I think, in all honesty, when I assess it, when I look at it, that neither you two just aren't good for each other. And it may be because of what Ms. Ford says, that you want something definite. Just in the little bit that I've listened to.
They aren't good for each other. That should be on the thumbnail. That is a statement of this case. You two are not good for each other. I don't know how they didn't butt heads before this, but this might have been the worst prelim I've ever seen. Everyone's frustrated except the prosecutor. The prosecutor's sitting there like, I'm just trying to get through this. Man.
That's not going to happen in this case. Right? But maybe you could then maybe have closed the gap between each other had you looked at everything. Maybe not. Maybe you still wanted it to go a particular way because you got a lot of risk here. And maybe sometimes, I'm not saying that you've done this, but sometimes clients get locked in that they want this resolved. And regardless of what you're looking at, that happened. That you're looking at it, but you're not seeing it. Okay. So I don't think all of that matters. I'm not here to try to attribute blame to anybody or anything along those lines. I just have to, my job is to try to make the proceeding fair, regardless of whatever the outcome is. I just got to make it fair. So, yes, Mr.
Yeah, I'm just saying, if you're telling me they can do, if you're telling me, you can do such and such, and I ask you to show me that in black and white what the law says, I expect to see that, sir.
Yeah, but Mr. Epps, it doesn't work that way. That's partly what I'm saying. I could sit there and show you something that is black and white in the law, but what people don't understand is whether or not that black and white that you're looking at is going to apply is going to depend upon what the facts are that are leading up to it. And so sometimes it may look like it does, that it applies, but it doesn't apply. And there are reasons why, and some of them are very nuanced reasons as to why it doesn't apply. If it were as easy as what you said, we really don't need lawyers. Because I could just, well, you don't need anybody. I just put these facts into a computer and say, this is the result of it. That's not how it works. And it doesn't work that way for a reason, which I won't necessarily go into, but you know, all cases have their nuances and their little pieces to them. One change in something can change it.
Yeah, he brought up the Sixth Amendment when he was trying to get the case dismissed because the victim isn't there. So that's why he brought that up. I'm guessing that's why he did, because he didn't really go into detail except for the Sixth Amendment. He just kind of blurred that out. He may have, but he's so hard to understand because the mic situation. But yeah, that's what I assumed when he brought it up. But that's not the first time he's made that argument.
The result on the other end. It would be, quite frankly, in a lot of cases, and I won't say malpractice, but it would be wrong for an attorney to say, here is the absolute result.
I'm not saying it'll be false, I'm just showing, I'm asking her to show me how to law. I came to her, sir, and said, I got the right to face my accuser, sir. Here it is.
Right, but can I just say that? Can I just say this? You're right. You have the right to confrontation, but did you hear the case law that applied? And that is, hold on, because that's what it says. But then there are certain instances where that doesn't apply, like a preliminary exam. I mean, and there are reasons behind that. And, you know, everybody wants a simple answer, but it's not always a simple answer. It's just, that's just the way it is. But I'm going to give you your wish, and I'm going to give you Miss Ford's wish.
We're also dealing with love, I believe, and it's hard for most defendants to concede that there could be a conviction if a complainant doesn't want to go forward. It's inconceivable.
I know.
And the law is nuanced in this, especially in this area. And I feel I'm up against a brick wall kind of at the end of the day, that I might not be able to make it black and white. And I'm sorry to leave this.
And
first time.
no, but here's the thing. Here's the thing, Ms. Ford. And this is again what a lot of clients don't understand. They're looking at something in black and white. They get what it says. And I think you're right. I think Mr. Epps is very intelligent. And he sees what it says. The problem is, and some of this doesn't.
Have a good night, Erica. This video only has about 5 minutes left, and it's about to get real spicy. So if you can wait 5 minutes before you leave, you might want to.
In some ways make sense, but when you read that, that's not what it necessarily means by just the ordinary thought of what you're reading. It may mean something different, and then it means something different depending on what part of the proceeding you're at. You know, like, yeah, you say you have a right to confrontation, but guess what? You don't, at an arraignment, you don't have that right.
I understood that once the prosecutor said that, I understood.
I said it all last night and many other times. Oh my God, it's time for me to go. My time is, oh my God. Let's move on.
All right.
I'm not here to argue with her.
I'm not here to argue, but I'm here to clarify. So before I can do any more clarification, I think I should just.
Just everybody just hold on. Everybody just have a seat. Mr. Epps, please. Miss Ford. So here's what I'm gonna do, Mr. Epps, because this is your proceeding. I'm going to, on the court's own motion, that way I'm not granting your motion, I'm gonna do it on my own. I'm gonna give you new counsel. I'm gonna relieve Miss Ford of her obligation in the case. I'm gonna give you new counsel. It won't delay it, because that was the other issue. It won't delay it any more than what I would have had to anyway regarding the discovery issue. So it'd be October 8th, 2024 at 9 a.m. before me. I would just caution the people that while we've taken some testimony, because new counsel's coming in, and just to be fair, that we'll probably start over. We didn't get that far in on that. And the court, and I'm going to sign the order later, but I'll order it now, that the court will appoint David Burgess to represent you in this matter. He's already aware of it. He's already aware of the date. So he may, knowing him, he's tied up in court, otherwise he would have come down. I'm sure, knowing Mr. Burgess, he'll get to you. So when he shows up, don't think that it's maybe somebody you don't know, but that's him. Okay, but he'll be down to see you. Okay, and at this time, Bond. Thank you. Yeah, no. Just have a seat, Miss Ford. No, we're done. I'm done, Miss Ford. I'm done. I'm so done. All right, is that it?
Yeah.
All right. 14A stands adjourned.
All right, Erica, now you can go to bed. It's over. Man, this is no words. It ended the way it should have. They're gonna part ways. They need to have part ways a long time ago. I don't know how they didn't butt heads while they were prepping this case, especially with how much of a personality and the defendant is. All right, that's all I got, though, guys. That's all I got. Thank you guys so much for hanging out with me. I appreciate it. You are awesome. We had a great turnout tonight. Thank you so much. Mimi, thank you again for the extremely generous super chat. Thank you. Erica, thank you for yours. Sorry about my confusion. Looks like your brother dipped out, though. And Peeps and Johnny, thank you so much for your milestones. You guys are awesome. All right. I've got a really good one to start off the morning with tomorrow out of Texas. It's Judge Garcia. And oh wow, she's yelling, and it's spicy. It's good. So that's going to be released in the morning. But yeah, you know what? Who can we raid? Let's raid somebody. Let's raid. I should have had this set up already. I don't always remember to raid people. I'm really bad at remembering to. Is there really nobody on? Got one person on, but he's still, I'm not rating him. That's all I got. I see KCC's coming up, but doesn't give me a time, so I don't know when she's live. So we'll just call it a night. KCC's going live at some time. I don't know what time. It doesn't tell me. So you guys all have a great night, and yeah, I will see you guys later. KCC goes live at 9. It's 9:24. So I'm guessing that's probably the top of the hour. So yeah, I don't have anything to play right now, so I can't make this last that long. All right, you guys have a great night, and I will see you tomorrow. Let's go hang out with Casey 9 Central. Okay. Well, I got 9:30 and 9 Central. All right, you know what? I'll set it up to raid her. I'll just set it up to raid her. If you know, you guys can hang out there if you want to leave, but I'll go ahead and add it if she's going soon. You might hang out in the lobby for a little bit, but we'll at least set it up. And then you guys can make the decision. Okay. Have a great night, everybody. Until next time, bye.